5 seconds to go. Start. An employee against whom disciplinary action is proposed or likely to be taken shall be given a charge sheet clearly setting forth the circumstances appearing against him, and a date shall be fixed for an inquiry, sufficient time being given to him to prepare and give his explanation, as also to produce any evidence that he may wish to tender in his defense. He shall be permitted to appear before the officer conducting the inquiry to cross examine any witness and produce other evidence in his defense. He shall also be permitted to be defended by a representative of a registered union association of bank employees or with the bank's permission by a lawyer. He shall also be given a hearing as regards the nature of the proposed punishment in case any charge is established against him. In order to interpret, we would like to allude to clause 2e of the definition clause in the service code, wherein the expression bank has been defined to mean the Bank of Cochin Limited and not any other bank. Clause 2e of the service code reads, bank means the Bank of Cochin Limited. The judgment under challenge seems to have overlooked the implications of clause 2e of the service code. The objective of definition clauses is to avoid frequent repetition in describing the subject matter to which the word or expression is intended to apply. This is useful when the same word or expression is used more than once in the same enactment. The raison d'etre behind the definition clause is that while interpreting a provision, the defined word or expression would carry the same meaning as the defined words or expression are employed and used by the maker in the sense appropriate to the definition. The definition can be with the intent to attract a meaning already established by law, expand the meaning by adding a meaning, or narrow the meaning by exclusion. This general rule of construction laid down by the enactment is subject to the context, albeit the interpreter, to deviate from the defined meaning, should record reasons to show that the word expression in that particular provision carries a different meaning. Contrary context is not to be assumed or accepted easily in the absence of indication and reason to differ from the defined meaning. The repugnancy will arise when the definition meaning does not agree with the subject in the context. Repugnancy is not indicated and does not arise in the context of clause 22(9)(a) of chapter 8 of the service code by mere absence of article the in clause 22(9)(a) before the word bank as held in the impugned judgment. This is too weak and feeble a reason to discard and override the defined meaning, which is the general norm and not an exception that has to be justified. Deficiency of the does not disclose abandonment of the express definition of bank wide clause 2e of the service code. Absurdity or even ambiguity is not obvious or even palpable. The word bank in clause 22 9a can be validly and effectively interpreted as per the definition clause as referring to the Bank of Cochin Limited and not any or other banks. Therefore, the reasoning solely predicated on non-existence of article the before bank in clause 22 9a of the service code does not justify inference of repugnancy in the context of the subject matter, including the intent behind clause 22 9a of the service code. Now, we need to advert our attention on the aspect of the choice of representation in domestic inquiry. Both sides rely on the dictum of this court in National Seeds Corporation Limited versus KV Rama Reddy, which hold that the right to be represented by a third person in domestic inquiries tribunals is based upon the precept that it is not desirable to restrict right of representation by a counsel or agent of one's choice. The ratio does not tantamount to acceptance of the proposition that such a right is an element of principles of natural justice, and its denial would immediately invalidate the inquiry. Representations are often restricted by a law such as under section 36 of the Industrial Disputes Act 1947, as also by certified standing orders. The aforementioned two decisions ascribe to catena of decisions, including English case law on this subject, which accept that the right to be legally represented depends on how the rules govern such representation. Further, if the rules are silent, the party has no absolute right to be legally represented. However, the entitlement of a fair hearing is not to be dispensed with. What fairness requires would depend upon the nature of the investigation and the consequences it may have on the persons affected by it. Stop.